Is the microphone working? I think it's really hard to tell here.
Check.
Okay. So thank you all for coming and welcoming Domingo LLagostera. He is a senior associate at Blank Rome LLP. He received his bachelor's in biochemistry and mathematics from Trinity University. He then went on to work in the pharmaceutical industry and in clinical research for a couple of years before he received his JD at the University of Houston Law Center. His main concentration is patent litigation, and today he will be speaking with us. So thank you.
Thank you, Roxanne. Hello, everybody. As Roxanne said, I do have an undergraduate degree in biochemistry, but I'm first and foremost consider myself a lawyer. So my goals today are to hopefully explain how my undergraduate degree bridges into IP law and give you a general overview of IP law without getting too far into the weeds on legal issues, but more of what a patent is, how to obtain a patent and prosecute and enforce it, and what an IP lawyer does in that process, and particularly how it relates to our field in the biochemistry, biomedical sciences, chemical world. So first I want to tell you guys how I became a lawyer and got to where I am after graduating with a biochemistry degree. So, and this will give you a little bit of context. I graduated in 2004 from Trinity University, and 10 years at least before that, I thought I was going to medical school. Did the pre-med curriculum, prepared my medical school applications, took the MCAT, did well, was set to go. And then I did a very foolish thing, and I got into a rock band and decided I wasn't going to go to medical school, so I did not send off my applications. I moved to Austin, played on 6th Street for a number of years, and in that time I also worked for a pharmaceutical company called PharmaForm in North Austin. And what I did there was mostly analytical chemistry. And really, the reason I worked there was so that I could pay the bills while I was in the band, and there wasn't a whole lot of opportunity in Austin in the research industry. Time passed, the money wasn't working, the band thing wasn't working, it was getting a little bit too stressful, and so I decided to choose a different career path. I did not want to go to medical school and spend another 9 years in school and residency and all that. And so I looked into law and how I could use my technical degree in intellectual property. And it was interesting to me. It was only 3 years of school, get in, get out, and a good paying job afterwards. So I decided to go that career path and haven't looked back. It's really the best decision I could have made for myself. So my goals today, aside telling you how I became a patent lawyer, is to give you a general overview of intellectual property, take you through the patent procurement and enforcement process and what a patent attorney really does for a living in that process. There's really 4 buckets of career paths you can take in IP law, particularly patent law, and that is patent prosecution, which is the process of obtaining a patent. There's the transactional side, where you are involved in licensing licensing patents or business acquisitions and investigating IP portfolios of companies and to value the company. There's investigational aspects of intellectual property law where you're, for example, freedom to operate, where you're looking at what's out there in the world and whether or not your client is free to practice whatever they're doing without infringing on anyone's patents. And then there's patent litigation, which is the bulk of what I do. Now, some people stick to 1 or 2 of these things. I do a hybrid approach and really do all of them, but I would say 75% of my career is in patent litigation. And then I'll go through law school and what that's like, and then biotech, biomedical opportunities in the IP world. So there's really 4 types of intellectual property, and for our purposes today, we really only care about the last 2. You've probably heard of all of these. So you've got copyrights, which is expressions in authorship, trademarks like the Coca-Cola brand, trade secrets. These are things that technologies that companies keep secret and do not share with the world, and they're really considered the most valuable type of technology. And then there's, the most valuable type of IP, and then there's patents. Our degrees y'all's degrees in biomedical sciences really don't have anything to do with copyrights and trademarks. You can be an IP lawyer without a technical degree. Really where the technical degree comes in is when we're talking about trade secrets and patents, because that's really what we're talking about, technology. Has anybody here seen a patent before? You have? Anybody else? Yeah? Well, here's an example. This is actually a patent that I prosecuted for the University of Houston and issued in 2015. And I just took snippets from it so you can see what one looks like. So this is the cover page of a patent that just has really biometric information about a company and the inventor. And then the patent consists of drawings. So this is a virology application where the inventor at the University of Houston was modifying a herpes simplex virus to make it into an oncolytic virus for cancer therapy. And so you would have pictures in the patents that guide the public to understand what it is you're actually inventing. So here he was splicing the herpes simplex virus genome. And then you have a written description that explains what you invented, and at the end of the invention is what's called a patent claim. And this is a patent claim that actually issued, and you can see what that looks like. And it's one sentence, but this is the most important part of the patent because it is effectively the metes and bounds of your property. So if you have like real property, you have a survey of what your house looks like, that defines the borders of your territory. The patent claim is what defines what it is actually your property that you're protecting. So that's what a patent looks like, and particularly a biomedical patent. So what are patents? Patents provide protection just for functional concepts. So they're useful inventions, but they cannot be abstract. So for example, Newton couldn't, once he discovered gravity, he couldn't patent the law of gravity. It can't be something that occurs in nature. It has to be something that you actually created. So no math algorithms, no abstract principles, no laws of nature. None of those things can be patented. Patents are extremely expensive to obtain. Your typical patent application, seeing it from filing through prosecution, can cost anywhere from, I don't know, $20,000 to $30,000. And then once you have the patent, to enforce it can cost you over $1 million easily. So your invention, to obtain a patent, it has to be something that's useful, it has utility in the world. It has to be novel. It can't be something that came before you invented it, and it cannot be obvious. So if there was something that existed before you filed your patent application, you file a follow-up patent, it could not have been obvious in view of the previous filed patent applications. So these are very tricky, difficult legal hurdles to get over, but effectively what you're trying to do is show that you invented something that no one could have thought of before. Once you get a patent, if you do get a patent, you get a term of 20 years from the date of filing. So sometimes patents can take 10 years to issue, and if it issues 10 years later, you've already lost 10 years of your term. That's part of the give and take of the patent system under our Constitution. Part of it is that you fully disclose your invention to the world so that the public can see what invention you've created and build off of it and improve. It spurs further innovation, and in return you get a limited monopoly, and that's the 20 years that you get. There's also design patents and plant patents, which are very strange. They cover asexually reproduced plants. I've never dealt with plant patents before, but those exist. So what a patent does and does not give you, many people are mistaken that a patent gives you an affirmative right to do something. That's not true. It gives you an exclusive right in what you have patented. So for example, if I invent X, and I get a patent on X, that doesn't mean I can go practice X because I might be infringing on somebody else's patent. What it does is it gives me the exclusive right, meaning that nobody else can practice that invention that I've patented. And it excludes people from making, using, selling, or importing your invention, your widget, whatever we call it. So why do companies get patents? Well, they're extremely valuable assets to the company. They can be worth millions, billions of dollars sometimes. Like consider a company like Apple, who has, I think they have somewhere upwards of 50,000 plus patents now. Just a giant patent stack that is very valuable in terms of getting investments into the company. It's valuable in terms of taking defensive positions. So, for example, when Samsung sues Apple for patent infringement, Apple takes their patent stack and slides it right up in front of Samsung and as a litigation threat. So it's a defensive mechanism to keep you out of court. It protects your investments, obviously. If you want to be the only one in the market that is selling your invention, it prevents others from coming up with generics during your patent term, which gives you a lot of value in the market for that 20-year term. Some companies don't want to exclude people from the market and would prefer to obtain licensing revenue. So you can come up with some invention, get your patent on it, and then you go out and you find people who are practicing your invention and you solicit royalties from them. And then you just bank off of a royalty stream from those companies. So there's different approaches depending on what the company wants to do. They either may get more value out of licensing or they may get more value out of keeping others out of the market. There's some other reasons to have it, but at the end of the day, the message is that they're extremely valuable assets to companies, and companies spend a lot of money on intellectual property and their intellectual property attorneys to make sure that that value is maintained. You've probably seen Shark Tank where Lori always asks, do you have a patent on your technology? Where there's a reason for that, because she doesn't want others coming in and superseding that invention with something better. So I'll walk through the patent process pretty quickly. Oh, by the way, if you guys have any questions, don't wait till the end. Please, raise your hand and we can get through it. So the patent process, step one is innovation, and then prepare and file an application, and then you wait and you wait and you wait, and it's a very long time because our government is slow, no surprise there, and then the patent ultimately issues or it gets abandoned because you can't get it through the patent office because maybe it's not something that was actually new. So innovation, this really starts with the inventor and where the patent attorney starts coming into the process. You've got, we'll go back to the patent application I had from the University of Houston with the inventor. So he's a research professor, Dr. Zhang at the University of Houston. He's working in a lab every day. He knows what's out there. He comes up with something new. And then the process starts with the patent attorney. Are we ready to file a patent application? And this is called the patent prosecution process. It's an independent process from enforcement and litigation. During the innovation stage, well, let me back up for a second. Innovation mostly comes from inventors who are deeply entrenched in their field. So, a lot of us think of innovation as we're sitting on the couch and we come up with some brilliant idea and we're like, oh yeah, I'm going to do that. I'm going to go patent it. Well, 99.9% of the time, that's not the way it works, because almost always somebody has already invented what you just thought of. There are exceptions, like if you've seen the movie Joy, where she came up with the mop handle. That was a unique thing she came up with, and she made a lot of money off of it. But most of the time, innovation comes from tech companies who invest a lot in research. These guys, men and women, they know the landscape of what's out there. They know all of the players in the field, and they know when they've got something new and it's ready for patenting. You as a patent attorney, you step in and you work with the inventor at this point of innovation, and you've got to figure out if what they have come up with is ready for patenting, because if you pull the trigger too early, you risk disclosing what you invented and then having a patent application that gets denied, and then it's too late because you've already disclosed it and it's out in the public and you've basically opened the basket of secrets. So you as a patent attorney work with the inventor to figure out, have they conceived of something? Is there conception of an invention? Usually there is. And has it been reduced to practice? That's the hardest part, especially in the biomedical and biotech world.
How frequently are things denied?
How frequently are patent applications denied? Well, as you go through the process of building your patent claim, it always starts very broad, okay? And at some point, you're facing so much prior art and rejection from the patent office that you have to narrow down your claim and narrow it down, and at some point it may become just valueless because it is at that point so narrow that you abandon. So it's really hard to get a sense of why a company abandons something and how often it happens, but I would say routinely denied, I would say 50-50, it's about 50-50. Yeah, but there's varying reasons for why a company ultimately withdraws from an application. It could be that it's gotten cost prohibitive, it's just too expensive, or there's too much prior out there, or ultimately you just decide we've gone the next step of innovation, let's just let that one go and move on to the next step. So there's a couple of ways the patent lawyer steps in this innovation process. And the top two are really, really rare. So sometimes a company will ask you to do a prior art search before they invest in filing a patent application. That can be very expensive, and the cost of that can outweigh just filing the patent application. There's also a philosophy that if you've developed something that you believe is new, it's a patent office's job to find prior art and reject your patent claims, and you start going out and digging for prior art references, it raises other problems like willful infringement of a patent, which we'll talk about later. But some companies do like doing prior art searches, some companies do like doing a patentability opinion. For example, here's my invention, here's what I want to claim, can I get this through the patent office before we spend money doing it? And that's something that a lawyer would do. And then there's patent landscaping, which I just did one recently, and it's go out and find every patent you can find on this widget, so I can see what all is out there, and I know where the innovation points are going to be in this landscape. And then, as I said before, is the invention ready for patenting? Now, there's very big challenges in the biomedical science and biotech world when it comes to, are we filing too early? Probably in more than any other field, this is the biggest problem, because I'll give you a real-world example in that patent I was showing you, that the inventor had done in vivo and in vitro testing on mice of his modified herpes simplex virus, and it selectively killed pancreatic cancer cells. So he wrote up this publication on it, we turned it into a patent, and I think he also included like lung cancer in there or something like that. Now, when you go down to the patent claim and what you can actually cover, of course the inventor is saying, I just cured cancer. Like, this should not be limited to this particular genome deletion in such a small confined space to pancreatic cancer. They want to claim the world because they have invented what they think is the cure to fusogenic killing of cancer cells. He quickly learned that that wasn't going to fly, but we were able to get pretty broad patent claims out of it. So the point is that in the biotech world, it's very difficult when you discover something to say it applies to so many aspects, and for example, just multiple types of treatment without having tested and having data proof of all of those treatment types. But at the same time, it's not practical to do that. You cannot take something that you've invented and test it every single aspect that you can possibly think of to cover the entire genus of treatment. What you do is you have to determine as the patent attorney, has the inventor given us enough testing for us to say, a person of ordinary skill in the art would look at all of this data and say, yeah, he's got it. Even if the data is not here, we know that it covers brain cancer, it covers breast cancer, et cetera. So that's really the trick of working with the inventor and figuring out, did you go far enough, not crazy like 10 more years of research, did you go far enough to get enough that we have enough to file a disclosure and get a broad claim to cover selective killing of all cancer cells with your modified gene, which ultimately, in that case, we did. So preparing a patent application, use the patent attorney, collaborate with the inventor, usually have an initial disclosure interview, and there's lots of follow-up questions, and you're working very closely with these inventors to build a disclosure. And that's going to include this especially in the biomedical sciences, this very detailed written description of what your invention is. All your experimental data will go into that written description to support the claims, because that's the point. The written description is supposed to support your patent claim, which is your metes and bounds of your invention. You'll have drawings in there, as I showed you, and then, of course, your patent claims at the end. So the written description, I've already explained this, but basically it's a very detailed description. It's got to just be sufficient to support your claims. And a lot of inventors, like university inventors, will take an actual, like a grant writing and just send that to the patent attorney and have them put that into a patent application. And for some patent attorneys, it might be a little bit too technical, but that's sufficient as long as a person of ordinary skill. It's not whether the public could pick it up and understand it and see that it supports the claims. It's whether a person of ordinary skill in that art could pick it up and understand it. So if you have a biochemical application, could a biochemist pick it up and understand that, yeah, this data supports these claims? And as I said before, prior art search is not required in the process. So drafting the claims is really the heart of what a patent attorney is doing, because what you are trying to do is foresee the future and what you can prevent people from doing what you want to prevent, and you really want to get as broad as coverage as possible without stepping on to the prior art. And you want to be clever, and a patent application has multiple claims, not just one. So you could have up to 20 without paying any further fees, and you can claim what you have in a lot of different ways. And the reason you do that is protective, so that when you get into litigation, if you do, and one of those claims falls because maybe it's not supported by your specification, or maybe it's too broad and gets knocked out by prior art, you've got something to fall back on. So the current queue for a biotech and for applications biotech, this includes biomedical also, is about 13 months to a first office action. So once you've got this disclosure, you and the inventor are happy with it, you file it, you pay a flat fee to the USPTO, and then you wait. And it takes about 13 months for the office to respond. So they'll get that patent application, it'll go under the bottom of the stack, and then the data says 2 years to issuance. I think that's a little aggressive. A lot of the applications I've done and other people in the biotech field, it's usually taking about 3 to 4 years. But that's to get a patent issued. And the prosecution process, the inventor really is not so much involved in the prosecution process. He or she may sign off on the exchanges that you have with the examiner. So during the patent prosecution process, after you filed, what's going to happen is the examiner is going to always issue a rejection, no matter what. Even if you have definitely invented something, they will issue a rejection because it is their job to get as much fees out of you as possible. So they will fight tooth and nail until you've convinced them that, okay, you don't need to pay us anymore, issue my patent. So this process is they'll issue an office action rejection, and then you'll respond to the rejection, tell the examiner you're wrong, or if they're right, then you narrow down the claims and you continue to whittle this down until you've convinced the examiner that this is the claim that should go forward, and the examiner agrees, and then the patent will ultimately issue. Now, before the patent issues, you can always file a follow-on application called a continuation application, so that you can continue to add. You can't add any new material, but you can continue to tweak the claims and make and put them in ways that, as I said, protect you for future litigation. So we talked about this a little earlier, but some ways that so now you got a patent issued, and so let me back up for a second. That process I just explained is called patent prosecution, and many IP lawyers, that is their sole practice. So you will find a number of boutiques, for example, in Houston, where all you have is attorneys doing the patent prosecution side of IP law. My firm, Blank Rome, we do have attorneys who are dedicated only to patent prosecution, but then there's litigators and transactional attorneys, so it's more of a hodgepodge. I do a little bit of patent prosecution for the University of Houston, probably about 10% of my practice is that. Really, that's personal choice of yours. It depends on where you land, if you end up wanting to go to law school, and what side of IP law you like, but you don't have to go in one direction. You can do a little bit of mix of both, and I think it is actually beneficial to do both because clients like to see that you have a broader scope of IP practice than just being very narrowly focused. Yes?
Two questions.
Sure.
I imagine it may be rare, but in the prosecution phase, what if there are two different inventors with a similar idea or very close ideas that they're trying to patent?
Yeah.
Who would then get the patent protection patent?
Well, today it's the first inventor that filed.
Okay, by filing.
Yeah, it's by file date. It used to be before the American Invents Act came out in 2012 that it was the first inventor. So even if they didn't file, let's say they filed on March 1st, but they have proof that they invented it in January, then they can prove up to the patent office that their invention actually started in January, and that's how they claim priority. But today it's strictly by filing date, and that's actually how the rest of the world does it, which is why the U.S. shifted to that model. Second question? Yeah.
Off-label applications. How do they, are they patentable? For
What?
instance, I think blood pressure medicine was found to do something with Viagra and off-label applications. Are those off-label applications?
They are, yes. So assuming it's not obvious over the previous prior art, you can claim, so there's different types of patent claims you can have. You can have a product claim, which would claim Viagra, and clearly you couldn't do that in an off-label application, right, because Viagra has already been patented. But you could also have a method claim, which would be a treatment claim. The problem is if you get that patent, how are you going to practice it, because Viagra is already patented. Now, if you get if the Viagra patent expires, then now you've opened the door to be able to use that treatment. So what you could do, and many companies will do this, is do a sort of cross-licensing. So the company that developed Viagra will recognize that that's a valuable treatment, and vice versa, and they will cross-license each other's patents. So leveraging your patents, once you get these patents, what do companies do with them? Going back to the University of Houston, they do very often leverage licensing revenue for their patent portfolios. Also, they like to disclose their technologies and get patents and offer their technologies for public use, part of the university policies. So maybe they won't block the market from doing it, but they will make sure other people cannot block the market. Block the market, very common patent leverage, and get paid. And there's a number of ways to get paid on a patent. And there's the peaceful approach where you send, and by the way, this is all the patent lawyer that's kind of doing all this process, but there's a peaceful approach where you send an invitation to license, and I put it in quotes because it's a nice way of saying, if you don't license my patent, I'm going to sue you. But we call it an invitation to license, and you send a letter and you say, hey, we've got this patent, are you interested in licensing it? Let's start talking royalties. And then there's the aggressive approach, of course, and some companies right off the bat will go with the aggressive approach because they are very conservative about their patent portfolio and don't want anybody practicing it, so they'll send a cease and desist letter, which is stop practicing this product or I'm going to sue you. And if the company ignores you, then the next step is to file suit in federal court for patent litigation. And patent litigation is exclusively in federal court. Trade secret litigation is in state court. And then out of federal court, ways you make money, you can get an injunction and enjoin that company from putting their product out on the market, which ultimately will boost your revenue. And you can ultimately obtain licensing royalties from that company if they lose. And in very rare cases, you can collect from that company any profits that you lost as a result of them infringing your patent. It's very difficult to prove because you've got to make some nexus between the profits that you lost and the profits and the sales that they made. So that's really the way you leverage patents. So I'm going to talk a little bit about litigation now because that's mostly what I do. Is it worth it? In many cases, in most cases, no. So the time period for a lawsuit is 3 to 5 years. It's a long time. It's going to at least cost you $1 million, and all of that is mostly attorney's fees to get through trial from filing. And the stakes, depending on who's suing, patent trolls, I'll go over that in a minute, maybe their maximum damages is $50,000 to $350,000. So you can already see that if it costs you $1 million to go to trial and the maximum damages at stake is $350,000, nobody's going to trial. And then you get the rarer cases where you've got big companies like Apple and Samsung who are suing each other for millions of dollars, and then in that case, it might be worth going to trial. So because of this dynamic in IP litigation, greater than 90% of cases settle out. Very rare to go to trial. It's just never worth it. I'll give you examples of patent trolls. Do you know what a patent troll is? So a patent troll is called a non-practicing entity. The patent troll is a kind of a nasty way of referring to a non-practicing entity, and what that means is it's a company or a person who owns a patent but doesn't do anything, doesn't produce any products. Literally, John Smith sitting at home, he's got a patent. He goes out and he sues 50 different companies for patent infringement, even if they're probably not good faith basis lawsuits because they're not infringing. And what that NPE is doing is settling out with each of these 50 companies for $20,000. And of course, the company's going to pay that guy $20,000 because it's not worth $1 million to litigate the issue. So this is a big problem in our patent system. And so John Smith has now made a ton of money over a patent without having to do anything. And there are IP firms in Houston that only represent patent trolls, and they do it on a contingency. My firm does not do that. We defend only against patent trolls. We don't represent NPEs. So that's a big problem, and Congress has been trying to figure out how to solve that problem for a decade and still can't. But anyways, the point is, very expensive to litigate. You've got to have a client who's willing to spend the money, dig in their heels, and fight. Otherwise, really the job of the patent attorney is follow the steps of litigation and try to figure out a way to get out of this case as quickly as possible, either by settling it or by getting an early judgment in your favor that basically dismisses the whole trial. So this is a patent litigation overview, and this is for any type of case, including biomedical cases. It's all the same. It's unique to the federal litigation system because IP law is really like its own kind of subset of law. It's very specialized, and it's technical. So you have steps in the IP litigation process that you wouldn't otherwise have in a normal litigation, and I'll highlight those. But so the first thing you have is the filing of a complaint. So let's say in a biomedical case, Amgen would sue some company and file a complaint in federal court, only in federal court, in the proper jurisdiction, and then there will be an answer and counterclaims from the defendant. Then you'll have a scheduling conference with the judge. And from there, you've got two steps that are unique to patent law, and that's your infringement contentions and your invalidity contentions. And the infringement contentions is where the plaintiff lays out their entire infringement case, and the invalidity contentions is where the defendant tries to invalidate the patent. That's a defense to an assertion of infringement. Once those two major pieces of the litigation are set out, then you go through the discovery process. And discovery is time-consuming, it's extremely expensive, and it's basically the two opposing counsels fighting each other about what should be disclosed, produce your documents, answer our questions about X, Y, Z. It can last over a year, and it is probably, leading up to trial, the most expensive part of the lawsuit. You also get a lot of motions practice, motions for sanctions and discovery misconduct. It's really it's like a cat fight the entire time, like two little kids fighting. Once you get through the discovery process, then you have another step that's unique to patent litigation, and that's called the Markman hearing. And the Markman hearing is the judge construing the patent claim. So you can imagine you've got a real estate survey, and it's very easy to understand what the borders of your property are because it's just basically like a fence line, right? There's no disputing that. But it's very difficult to understand the full scope of something that's written in words. the words can be very confusing, ambiguous, and so the Markman process, the judge, here, their job is to determine what the claim terms mean. Not all of them, but the ones that the parties say are disputing about their meaning. So that's a big part of the patent litigation process. It's also a huge point of settlement, because once the judge has said the claim means X, then most often the parties already know whether or not they're going to win or lose a trial. After that, then you have experts, they submit their expert reports, and then you go to trial. So that's basically the format of a federal lawsuit, and only the Markman hearing and the infringement and the invalidity contentions are unique to patent law. Some attorneys, IP attorneys, are involved in every step of this process. I am involved in every step. Some of them stop here and do not go to trial, and trial attorneys, specifically like seasoned trial attorneys, will come in at the end of a lawsuit and help the patent litigators actually litigate the trial, because they're good at opening arguments and arguing to the jury. And some IP lawyers are only involved in the technical side of a patent litigation. So they're involved in consulting about whether something infringes. They're involved in the prior art and invalidity searching and defenses. They're involved in the construction of the patent claims. Apart from that, they really step out of the discovery griping and experts, and well, they'll work with the technical experts, but they won't get involved in the damages side of the case or trial, or they're not going out and doing oral arguments. So if it's not your bag to speak and go up in front of a judge, if you don't like to do a lot of adversarial writing, you can still have a role in patent litigation by being a technical consultant on the case. So quickly, risks of litigation for the plaintiff. It's extremely expensive, and the plaintiff could lose and have to pay. So as soon as that plaintiff files a lawsuit, when the defendant answers, they're almost every time going to come back with some counterclaim. And it could be a counterclaim for antitrust violations, for improperly trying to monopolize the market. It could be a counterclaim for patent infringement. So the defendant might also have a patent, and this is where, like Samsung and Apple, they have their patent stacks. They start suing each other back and forth. So it's a risk to the client, and as soon as they go all in and sue, they've got to know those risks, and your job is to walk them through those risks and anticipate what's going to happen when they sue. And then they could lose, and they could have their patent invalidated, which might be a horrible thing for them if it's a very valuable patent that they have licensed to a number of entities, and then they go and sue somebody and the court invalidates it. They're going to lose a lot of money. They could also be countersued for attorney's fees for a number of things like sanctions, misconduct, bringing an improper lawsuit in bad faith, and then, as I said, the counterclaims. For the defendant, also extremely expensive. They could lose. They could be liable for infringement. They could also be liable for a trebling of damages for willful infringement. So if you are found by the jury to have known about the patent and intentionally continued to operate, they could find willful infringement, and then the damages get tripled. And then also you could be liable for attorney's fees and potentially enjoined from your practice or from whatever product you're making. A lot of this litigation is bet the company litigation. So some of these companies, they have they have a patent portfolio, they do some products, so they're not technically an MPE, but they have one really valuable patent, and they go to litigation on that patent, and if they lose, it could shut down their entire company, which has happened to a client of ours recently. So that's really the patent litigation process, and the attorney-client relationship during that process is really you as the outside counsel, assuming you're not in-house counsel, you're outside counsel, you're working with the in-house counsel of a company, usually their general counsel or their chief IP counsel, and they're looking for you to advise them on steering them through the litigation, and most often steering them through in the least expensive way possible. If you're in-house, then you are really managing the litigation in-house for the company and working with the outside counsel to make sure those guys are not ripping you off and that they're giving you the best advice to get through litigation cheaply. But other than that, the client relationship really varies. Some clients are very deeply involved. They want to see every motion you write, every paper you serve before it gets served. Other clients are completely hands-off, and they want you to just run the show. They trust what you're doing, and they don't want to be involved. You just update them on a status conference once a week or once a month. So there's a variety of relationships there. So that's it. I mean, that's like a quick run through of what IP lawyers do. There's really nothing. I did have, let me jump here real quick. So in the biomedical, biotech, chemical world, there's a subset of patent litigation called Hatch-Waxman Act ANDA litigation. Do y'all know what an ANDA is? So it's an abbreviated new drug application, which means, so you have a company that invents a drug, and they have to go through a very rigorous process with the FDA to get approval for that drug. But then a generic comes in and is ready to come out with the same drug once their patent term expires. They don't have to go through the rigorous process. All they have to do is prove bioequivalence. And if they can prove bioequivalence, then they bypass all the work that the first company did and get FDA approval. So this is a very specialized form of patent litigation because it only applies to the drug field. But what this generic company will do when they file a abbreviated new drug application is they have to make a certification, and that's that there's no relevant patent. There's a listed patent. There's an orange book at the FDA with all the biomedical and biotech patents, but there's a listed patent and it's expired, or there's a listed patent and it'll expire before approval. And then there's the big one, the paragraph 4 certification, and that's that there's a listed patent, but we don't infringe and it's invalid. And if the generic company makes that paragraph 4 certification by statute, it's automatically considered patent infringement. So you make that paragraph 4 certification, you have to notify the company that holds the patent that you made a paragraph 4 certification, and then they can sue you for patent infringement, and then you go through the process of litigation. And then one thing I'll add, because the FDA process is so long, it could really eat up a lot of time of your patent term. So under the statute, you get an extra 5 years above the 20, or 14 years of total effective life of the patent, whichever is less after issuance. So that's a specialized type of litigation. I don't do ANDA litigation because most of this litigation is up on the Northeast coast where all the pharmaceutical and biotech companies are, which I'll talk about in a minute. But before I get there, let me just briefly go through law school. If you're interested in law school, so you obviously have to take the LSAT, and it's a more of a test of like logical thinking and analytical thinking. Law school is very hard. It's a lot of work. It is super competitive, but I enjoyed it, and every colleague that I've ever worked with loved law school. Law school is a little different than, I don't know how graduate school is because I didn't go to graduate school, but it's definitely different than undergrad, where it's the Socratic method, meaning it's a constant dialogue between the professor and the students about the law instead of just a lecture. A lot of reading, a lot of writing. That's basically all you do in law school is reading and writing. I will say that I actually absolutely hated writing before I went to law school, but learned to love it and now do love it. And it's expensive. So you consider law school, you definitely want to do it with knowing what you're going to be paying in tuition and doing your best, because your career opportunities are directly correlated to your grades in law school. So the first thing you're going to do, or a company is going to look at when they get your resume, is what was your law school, and it's a cutoff. You don't make the cutoff, they will not interview you. And I'll get to that in a second. So IP classes to take if you're interested in going to law school. So the first year of law school, you have to take the core curriculum, and it has nothing to do with IP. It's civil procedure, criminal law, constitutional law, real property. Maybe in your real property class, you'll get a flavor of intellectual property. But in your contract law. But in your second and third year, that's when you can start taking IP targeted classes. And so if you're going to go into law, I'd recommend taking an IP survey course, patent law, trade secret law, and if you are considering litigation, definitely evidence and a trial advocacy class so you can get trial practice. Excuse me. I discussed this, but really your career options as an IP lawyer are, skip the first one, I'll go back to that, patent prosecutor, a transactional attorney, investigation, patent litigation, or you can do a hybrid approach, which is what I do. And the reason I do a hybrid approach, as I said earlier, I think it's a value add to clients, because clients, when they call me up, most of the time they don't have litigation questions. They have general IP questions they want answered. And then trade secret litigation. The first one, patent agent. So you can prosecute patents without being a patent attorney, meaning you don't have to go to law school. What you have to do is you have to take the patent bar with the PTO. And I believe biomedical sciences is a degree covered by the patent office. But it's a great career path if you like patent prosecution and to make pretty good money. You'd have to study for the patent bar, of course, and that would take a number of months, and then you take a 5-hour test, and then you're done. And there's a lot of career opportunities out there. So law firms like mine, we have patent agents that do nothing but prosecute patents. Where the difference is between an attorney who prosecutes a patent and a patent agent who prosecutes a patent is that the patent prosecutor is really the patent attorney is really the one involved in crafting the claims, because that's where the legal issues come down to, like what is the proper legal scope of this claim, anticipating future litigation. So usually you'll have a patent agent working hand in hand with a patent attorney. This is probably what you care about the most. So law school grades, as I said, are really a gateway to an interview. If you are looking to go into big law, which would be like your Baker Botts, Fish and Richardson, Vincent and Elkins type of firms, mostly all you're going to be doing is patent litigation. First-year associates, I think right now are making about $180,000 coming in. This is all public. You can look this up. Through the 9th year, they're making about $280,000, and then bonuses are as big as $100K. So very, very good salary. Mid to small law. Oh, and you can see top 10 to 15%. So it's very important if you are aiming for something like big law and that type of salary that you buckle down and you do the best you can in law school, because you won't even get in the door typically without that kind of GPA. Mid to small, obviously a wider GPA range. They do litigation, transactional, investigational. I work at a mid-sized law firm. First years are about somewhere around 145, 9th years around 230, depending on the law firm. And then bonuses can get as big as 60K, sometimes bigger. It depends on if you're bringing in your own business. And of course, the salary goes up if you make a partner at the law firm and you're bringing in a book of business. So this is where it gets tricky for us, and that is where do we go with a patent degree? Because really, like the core of IP litigation are going to be your electrical engineers, your mechanical engineers who are litigating in the software space. There's a lot of drilling technology that is litigated here in Houston specifically. So staying in Houston, your best bet in the IP world is going to be patent prosecution, and particularly working with universities, because honestly there's not a whole lot of biotech companies out here, not near as much as there is out on the Northeast coast. If you want to get into biotech patent litigation, specifically in ANDA litigation, Philly, New York, Washington, those are going to be the places to be for that kind of thing. How I made a career here, probably less conventional than most people with biotech degrees who go into patent law, and that really is honestly that I do not do much biotech patent litigation. So I do have a healthy stock of biotech patent prosecution work with the University of Houston, but I mostly, just by chance, transitioned into drilling technology and software, and that's pretty much all I've ever litigated. Now, that's not to say there are opportunities that you can work remotely. So if you're from home in Houston, you can do, here at home in Houston, you can do ANDA litigation with maybe a satellite office out in the Philly area. I did a little bit of that when I was working at Aiken Gump before I went to Baker Blank Rome. And so there are those opportunities. But really, if you have your heart set on doing biotech patent litigation, then you should seriously consider that you would have to move. So let me just tell you what my day looks like as a patent attorney. So as an attorney, you have a ton of projects that are mutually exclusive. So there's a lot of things to juggle. But being an attorney, a partner once told me, is like being a juggler. You're juggling a lot of balls, but you cannot drop a single one. Because if you do, that's malpractice. So you got to prioritize a number of different projects, be extremely efficient, and have a lot of organizational skills. And then you do a lot of reading and writing. It's a ton of reading and writing. I mean, it's basically 99% of what I do on a daily basis. Writing emails, writing motions, writing letters, reading cases, reading opposing motions. And of course, there are oral hearings and trial if you ever get there. I love my job because every day is something completely new. I think that's a little less so of patent prosecution. For example, if you've got a giant book of business from one company and you know everything they're doing, you're constantly grinding out patent applications. But that's not always the case if you have a lot of variety of different types of clients. But in litigation, certainly never mundane, always something new popping up. And another aspect of what I try to do every day is bring in business. So part of being a lawyer is marketing and being a good salesman. Now, you don't have to do that. You don't have to strive for making partner and bringing in a book of business. You can be perfectly content doing patent prosecution work, being a senior counsel, and making a very good salary, and that's it. And a lot of people do that. Most people do that. I wanted to say, although I do have a biotech background, when you become a lawyer, you really are first and foremost a lawyer. It's not an abandonment of what you previously were doing. It's not an abandonment of your field. You really use that technical degree in ways that you didn't know you could use it. For example, I never did anything in electrical engineering, but my training in biochemistry, organic chemistry, R&D, the scientific method, it all helped me kind of figure that stuff out very quickly. So if you have a scientific mind, you'll find that you can do anything. But first and foremost, you are a lawyer. And then I do a lot of pro bono work, which is something that you don't often get to do if you're in a lab, and that's giving back to the community, doing legal work. I don't even do anything with patent law. I do immigration work, actually. And then learn. Every day is learning because it's called the practice of law for a reason. You are constantly learning new things every day. So that's really what my day looks like generally. I'm doing a lot of reading and writing, trying to bring in business, and sometimes doing pro bono work.